So I'm Chris Villasenor. I'm an attorney here in Carmel Mountain Ranch, San Diego area, and I've been a member of the chamber for probably 10, 15, 20 years. I'm trying to remember how long. But as a member, I've been in some breakout groups. I see some members here that I've been in breakout groups with over the years, and it's been great to be part of this chamber. And as part of that, they've asked me to give a hour and a half of some legal issues that I've seen in my practice over the 30 years to try to give businesses and individuals some insights on how they can protect themselves against personal liability. That's the biggest issue. You can run your business and that's great. But the worst thing is if they come after you personally, if you make a mistake. My practice is comprised of transactional with business, setting up new companies, doing contracts. I also do a lot of when businesses come to me and they want to buy, sell, they want to either exit, one shareholder or a member, or they want to come together. So, and also I do some business litigation, real estate litigation, dealing with commercial lease disputes, business disputes, contract disputes, and also some of my practice deals with personal injury. So it's all civil litigation or civil related. So let me go to my share screen and bring up presentation. So you should see that now. And so the first section that we're going to talk about is my company set up and operating with proper protections and compliance to avoid personal liability. And then at the end of this section, we'll have some short Q&A. So we don't, I don't bore you with an hour and a half straight of this fine print here. So the goal of a corporation or an LLC is really to protect against personal liability, and there's tax advantages as well. And I'm not a tax attorney, so I'm not going to be talking about taxes at all. And you're best to talk to your CPA about issues dealing with how you might use a company or corporation for tax advantages. But the thing I talk to clients about is setting up a company or a corporation as a separate legal entity to provide, let's say, a wall, like a firewall between you and the people that you're dealing with to protect you against personal liability. So the first thing that you really want to look into is when you set up a company is make sure it's set up properly. A lot of clients come to me and they say, well, why don't I just use LegalZoom? I said, you can use LegalZoom and they're going to give you a format or a template, cookie cutter type, and it might work for you. But there are certain provisions in some of the bylaws and some of the other the information they give you that is wrong. I've had clients come to me, they've gone through the LegalZoom route, they come back to me and they say, I need you to fix this because it doesn't suit my company. So that's the problem with LegalZoom. The other issue is that you don't typically have a chance to talk with a live attorney. They may have that add-on service. I'm not sure how much that costs, but typically I can either beat that price of LegalZoom by setting up the company and providing like 1 hour consultation. I try to do that for my clients. First thing with setting up a company is the filing of the articles of incorporation. With an LLC, it's an articles of organization that's filed with the California Secretary of State. If you plan to file outside of the state, then they have similar articles and other filing guidelines. I am a California licensed attorney, so I have had opportunity where I've helped clients file outside of the state. Typically, they have to find an agent in that state. There are some reasons why people file out of state. There are some advantages to that, but that's not part of this seminar today, this webinar. The thing that I talk to people about before they file the articles, before they embark on forming a new company, is to make sure that you have done due diligence on the name. A lot of people come back to me, they've set up a corporation, they come back, they start operating and they get a cease and desist letter from a company in town or somewhere in California. And they say, hey, did you know that you're using our name? We want you to stop using our name. And this company has already gone through and prepared all of their paper, all of their letterhead, all of this money they spent. Even they have a website And now they have to go and change it all. So you really should do the due diligence, finding out that your name is not taken, that it can be used. Typically, when you file the articles with the Secretary of State, it will reject them if there's a name that's too similar to the company name that you've chosen. But in some circumstances, there's companies that are not operating through the Secretary of State. They just have a DBA through a sole proprietorship, and they may have rights to that name. Second thing after filing the articles is preparing bylaws. Many people I find, they just file the articles. The articles in itself sets up the company. As soon as you file those, your company is active, and they typically will assign you a tax ID number. And usually will give you your social security number as the owner to go with, to have that EIN assigned, or TIN. That starts the company. But what you really need to have behind the company are bylaws or an operating agreement with an LLC. That's the rules of the company. That's the playbook. Like when you're playing a game, you look at the rules. Those are the rules that guide the shareholders of that company and how they are to operate. Those bylaws are the most important thing that you need to look at to make sure that they comply with what you're trying to do, your goals as an owner. And if you have two owners, it's really important that you look at those and are they going to work with the people that are involved in running this company? That's where the cookie cutter issue comes in, that you have problems, they didn't read it or they didn't really go in and amend it. So there's problems later on. Those are the clients that come to me after the fact to try to clean it up. You want to issue stock and you want to keep a stock ledger with an LLC. You don't have to issue units, but they have what are called membership units. And then when you set up the company, I always recommend doing an organizational minutes. You sit down with the company and we prepare minutes of the organization, and you vote on the officers, you vote on directors, you issue shares, and there's other things we can put into the minutes. All of that stuff that is prepared should go into a minute, like a corporate book. And we have a company that we use that we buy the corporate book and the stamp and the shares and all of that. You want to keep that in a safe place. You also want to set up a separate bank account. You want to keep separate accounting books. Initially, after you set up the company, you have to pay the Franchise Tax Board, State of California. Here they come. They want your money right up front. So you need to pay that minimum. I believe it's $800 right now. Within 60 to 90 days, you usually pay that up front. The other thing, when you set up a company, you want to make sure when you have contracts, you sign in the name of the company. So what people make mistakes is they've been operating as an individual or a sole proprietorship for years, and they set up the company and they're still signing John Doe as in the contract. You need to put by the person, and then you have the company and you put the president or vice president under that. You always want to make sure you sign in the name of the company to protect yourself as an individual. You want to make sure there's no ambiguity that you're not signing individually, and providing a personal guarantee on that corporate contract. So if you set up the next issue is if you set up the company properly, hopefully you'll avoid having that personal liability. But if you set up the company improperly, the owners, officers, and directors fail to follow proper corporate formalities, the owners can be held liable under an alter ego theory, or a creditor can try to pierce the corporate veil or come after you personally. And that's really what we're trying to avoid here. I've had examples where I've represented a company and its owners in litigation after the sale of a business, and they tried to come after the companies because they're saying for failure to pay on a debt. And they're saying, well, you say that it was in the name of the company, but the company didn't have any assets. It was just set up as a sham to try to avoid the payment to creditors. And they'll try to go into court and set aside the company and go after the people individually. So that's the worst case scenario that you want. Here are some things that businesses do to set up an alter ego theory, commingling of their personal assets with company assets, obviously. So you always want to have two bank accounts. You don't want to put personal assets in that company, the business account. And you also don't want to take money out of that business account unless you document it. Maybe it's a loan, or a promissory note, but you want to avoid that. So the use and diversion of business funds, credit cards, lines of credit for personal use. If a creditor finds out about that, that's another just check mark, a demerit of sorts that the courts can use to go after you personally. Failure to pay state and federal taxes or the minimum FTB, that could be used to actually suspend a company. Failure to keep corporate minutes or other corporate records, again, that could be used as another fact if you're not really keeping up the company. And fraudulent acts and unfair business practices. So even though you have a corporation, if you commit fraud against another company or a creditor, they can just bypass the corporation and go after you individually. So you can't say, well, you have to sue the company. Not in cases of certain types of intentional torts like fraud, theft, embezzlement, things of that nature. Certain things that can cause the termination of a company. So you have this company set up and one of the shareholders files bankruptcy, or you have to file a bankruptcy that could terminate the company. The failure to pay taxes can suspend a company. The failure to file the statement of information. Many of you have companies, you get this statement of information that comes in, a notice. You need to file that annually. I put in your sole proprietorships. So many people operate through a sole proprietorship, and if you have a name, you can file that with the county. It's called a DBA, and that lasts for a period of time, but that does not provide any type of asset protection. Okay. The other thing is that, so the sole proprietorship, I'll talk about this later. You can file a bankruptcy of the sole proprietorship, but, and it's widely used. And there's certain circumstances where you may operate as a sole proprietorship and you don't want to have a company, because the company, once you set it up, you have to file a tax return annually. And you have to, and with a corporation, when you set up a corporation, the default is a C Corp. Within a certain period of time, I believe it's 90 days, you have to file an S election to become an S Corp. You should do that through your CPA. So you always want to seek good advice from a good corporate counsel if you embark on forming a new company for your business. So at this point, we can go into some, if any of you have any Q&A before we go into the next section. All right, does anybody have any questions at this time? All right, I don't see any. If any of you do on the webinar, feel free to use your raise hand function, or you can just raise your hand the old-fashioned way and say hello. Let's go into the next section that I have here, and it's commercial lease abatement and termination. So for many businesses out there in this current pandemic COVID environment, people have difficulty paying their rent, okay? Obviously, they have difficulty paying. And for many businesses, payroll and the commercial lease are their biggest liability facing them. Fortunately, the state of California has stepped in to help businesses with the PPP loans and some other emergency relief. In some circumstances, the businesses are receiving this money, but they're still having problems paying their big lease every month. So there's a lot of information on the state of California website where you can look at all the emergency orders. Many of you have already probably seen this information, but I've kind of listed some information in the outline here. There was an order on April 6, 2020, emergency rule number 1, with respect to enforcing unlawful detainers against tenants. So an unlawful detainer is a legal action filed in the Superior Court, California, where a landlord can obtain possession of a lease from a tenant. Okay? Unlawful detainers are typically very quick remedy. You can go in there, you file the complaint against the tenant. They have 5 days to answer that complaint. If they don't answer that complaint, they can go in and get a default, and they can try to get possession within 2 weeks to 3 weeks through a sheriff coming in and kicking you out. Now, with emergency order, it's been very difficult. The trial courts were prohibited from issuing summons on these complaints to try to enforce unlawful detainer proceedings. Based upon my reading on the internet, that initial order was effective through September 1, 2020. As of September 2, 2020, the trial courts could continue on with the unlawful detainer actions and enter in defaults and set trials against tenants. Obviously, there's a huge backlog in the courts because these cases have been stayed for months, 6 months or so. The state left it up to local municipalities and counties, cities, whether or not they can continue to enforce the moratorium on the unlawful detainer proceedings against commercial tenants. And I'm not talking about residential here. Residential, it's a lot more laxed and a lot more tenant friendly. I believe a lot of these moratoriums are still in place. Talking about commercial tenancies. So when I read about the city of San Diego, I believe they said that the moratorium should continue till the local emergency is terminated or the withdrawal of the governor's order, whichever is first. And that was updated on August 26, 2020. So for people that live in the city of San Diego, I believe they still have some relief from that. In the city of Poway, they're following the state of California's order. So from what I can tell, it's up to the cities whether or not they're going to allow these actions to go forward. And at the end of this section, I'd like to hear if anyone has had any experience where someone was being evicted from a commercial tenancy. If you're faced with a situation where you cannot pay rent and you have a long-term lease, the first thing that you want to do is reach out to the landlord and try to work out an agreement. And I've represented numerous clients in this situation. And in some circumstances, you can talk to the landlord and say, Mr. or Mrs. Landlord, will you agree to an abatement of my rent? For example, we agree to a reduction of my rent, 50% or some number, or if the landlord won't agree to that, that's the first demand you might want to make. The second situation you might want to say is, will you agree to pay and include some of this rent at the end of my lease, or take a percentage of it and add it on to some of my lease payments in the next year so you can spread it out. You could enter into like a promissory note with the landlord to say, okay, we'll make sure we pay it, but don't evict us. Anytime you do any kind of lease abatement or some agreement with the landlord, you have to put it in writing. There's situations where I've heard about where they don't put it in writing and the tenant continues making partial payments, and the next month they get evicted. They're hit with a 3-day notice to pay rent or quit. That's obviously bad. You don't want the landlord to play tricks on you. You want to make sure that there's a good agreement in place. The biggest problem with tenants is they ignore the notices. They just kind of figure that they're going to go away if they don't continue to communicate with the landlord. Bad news. So the first thing to do is really communicate with them. And if you don't understand the agreement, you could have an attorney look at it. Even if an attorney looked at it for 30 minutes up to an hour, that could save the tenant months of problems and also a default on the lease. What happens when you read some of these long-term commercial leases, if you default on that, the landlord can tolerate the balance of the lease. And I've had situations right now where they've accelerated a balance of about a 9-year lease. It's about $350,000. The tenant vacated the premises already, but the situation was now they're going after them for the balance of the lease. So an unlawful detainer has two parts: one, gaining possession; two, the breach of contract for what's left remaining. An unlawful detainer is really purely a possession case. Many times, if you vacate the premises, let's say you just voluntarily walk out of your place, they're not going to go after you for an unlawful detainer. They will just sue you for breach of contract, like any contract case, for the balance of your lease. So if you can work out some sort of abatement or payment plan, you can try to avoid that terrible situation where they're coming after you. Before you vacate and just give up your space, if you can't work out an abatement situation, you might consider subleasing your space. Find another tenant. Find a broker or agent that can come out and try to find you another tenant. You could also contact the landlord's leasing agent on the building. You might have a sign out in front. Call them. Say, hey, can you find me a tenant that will take all or a portion of my space? In some situations, I've talked with tenants that have operated, like maybe they operate a printing franchise. They can't pay this huge 2,000 square foot rent. So what they've done is they cut it in half. They continue to operate in half of the space. They find somebody else to operate in the other half, but you have to get consent. You want to talk to the franchisor about that, whether or not you can operate in that size space. And you also have to get consent of the landlord. They have to sign off on that, any kind of sublease. Don't do this without the consent of the landlord, or you're going to be in breach of lease. Or you can find a tenant to take on all of your space. And if you're planning to move out and you definitely have made that decision that you don't want to operate in the space, you can't afford it, find a new tenant. And remember, if you can get the tenant to sign a new lease and have the landlord terminate your existing lease, that's the best case. If you've signed a personal guarantee, you want to have an agreement with the landlord that that personal guarantee is terminated. Otherwise, you could enter into a sublease or a new lease, and you have this personal guarantee out there that could last through the balance of that lease term or an extension of that lease term. Terrible. You want to get rid of that personal guarantee. In many situations, when you sign a new lease on your building or wherever you're leasing, try to avoid the personal guarantee. It's obvious. In some tenant-friendly environments that we may be going into right now with this pandemic, you may talk to the landlord and say, I don't want to sign a personal guarantee. I'm going to go, and you can look and search around and maybe avoid the PG. Let's talk. So in some circumstances, landlords have let tenants out through an early termination agreement. Okay, there could be situations, and I doubt it's happening now, but when you have situations where there's a lot of there's a lot of need for tenants, there's a huge backlog, there's no vacancies, some landlords have agreed to terminate your lease because they can enter into a new lease with another tenant at a higher rental rate. And they like that. So they'll say, sure, you want to get out, you want to terminate? No problem. We have another tenant ready to go. I doubt that's happening now. Again, document all landlord-tenant agreements in writing, review them with an attorney if possible. If you get into a situation where you have a lease problem, check your insurance policies for coverage, okay? Very important. You might even have business interruption coverage. Definitely always want to talk with your insurance agent to see if you have any kind of insurance that would cover you. Now, I don't believe I've ever seen a situation where you have insurance that covers you for breach of lease. I'll tell you what, I did have a situation where the owners of a business had to sign off and personally guarantee a lease. And I was able to tender it to their D&O, that's directors and officers insurance coverage, and they paid it. they paid the settlement that we had for an early termination of lease. It was this lease in La Jolla, and it was going to be about $300,000 to $400,000 left remaining on this lease. But because the landlord required that the owners to sign off on this personal guarantee, they found that under the directors and officers liability, that covered that act. I've never seen that happen again. It was the only time, but check. If your business is dissolving, you might consider walking away from that lease space if there's no personal guarantee. So you can always consider that. If all else fails, you may just have to walk away and dissolve your company. But the problem is what we talked about up on top, is will the landlord go after you for alter ego or try to say that your business was not properly funded and it was a mere sham, and they try to go after you personally. So that may have to be tested if you have no other option. Here's another thing that I put in here is be aware of successor liability situations. And I've been working with some clients in this situation. So in this situation, you have XYZ that's operating in a lease space or just operating in general. Doesn't have to deal with a lease issue. It could be any business issue. You shut down that company, and then the next day you set up XYZ company 2. Creditors are smart, they're savvy. They will go out, they'll try to go after XYZ company 2 for the liability against XYZ company number 1. And that's called successor liability. And you can search it on the internet. You can look up the situations of where that might come into place if you plan to do that. It has to be set up very carefully. And the biggest things that the creditors really look at, and especially like if you're in a bankruptcy situation, is many times they use the same name. They're the same shareholders and officers and directors. In some cases, they're in the same business location. They use the same CPA. They use the same bank account. That's the biggest problem. Okay? You have to set up a business bank account. You have to set up a new company or corporation. And you have to make sure everything is done independently and it's new. And in most circumstances, it's totally different. Generally, this successor liability situation may come into effect if you've sold your business. So this is a little bit of a different situation, but let's say somebody comes in and they want to buy your assets of the business. It typically will cut off liability to the buying company. So in some circumstances, someone might purchase a company and then they get sued by a creditor of the prior seller. Usually it's cut off unless there's an agreement that the purchaser has agreed to take on that liability. And in most cases, if there's a merger between two companies, that is an exception where successor liability would likely come into effect. And like I said, the mere continuation of the seller, that's where the creditor could come after the new company. And the transfer of assets for fraudulent purpose to escape liability. And that's called a fraudulent conveyance, where someone just transfers assets to their Uncle Louis to try to avoid getting attached from a creditor for no consideration. The creditor could go after and try to grab that back, get that asset back if you're trying to hide assets in a terrible situation like that. Okay, so I've just gone through this section. Does anyone here have any questions before we go on to the next section dealing with bankruptcy?
Chris, you have a question on the chat box.
Okay, let me look here. Okay, so I'm going to have, in order to get to that chat box.
Okay, I'll read it to you. It says the state is saying COVID-19 related. What does that mean? Since a lot of businesses are not directly shut down or lost customer from the order by the stay-at-home order, like in my business, customers are reducing their costs, which in turn reduces our income.
So David, could you restate the actual question?
Actually, I'll let Joe. Joe, go ahead, Joe.
All right, Chris. So when I'm asking that, so we're not shut down because we're an essential business. And so as an essential business, we're still running. We still got our bills. We're still paying everything. And they're saying COVID-19 related, which is at the stay-at-home order. Businesses are being shut down by the orders. We are not, but our income is reducing. So how do you claim COVID-19 related issues?
Yeah, so
That's that's the hard
I'm
part.
not an expert in trying to defend against and using the defense of COVID for the non-payment of a contractual liability. So, but for purposes of like a lease or situation, if you can argue that it's COVID related, in some circumstances, that may be enough to stop the courts from enforcing, like, for example, an unlawful detainer. I've seen that. If you can say it's a COVID related issue. But if it's a contractual issue, you owe a debtor, you owe a creditor funds for you to argue that it's COVID related. If you read your contract, the contracts will say many times that there could be an argument for frustration of purpose. But most contracts are not going to allow pandemic to be used as an exception under force majeure in a situation for non-payment on a contract. So I don't know if I've answered your question, but Amy?
This is kind of along those same lines, but maybe a little bit different. Do you know if COVID or the pandemic is something that would typically be covered under business interruption insurance?
From what I've heard through the insurance people that I deal with, the answer is no. I haven't heard of, and if anyone on this call knows, I haven't heard of anyone being covered for a COVID or a pandemic, and typically that's an exclusion under the policy.
Yeah, that'd be probably excluded because it's an act of God.
That's right. It's like an act of God.
Yep.
And then they even include explicitly in those policies pandemics and things of that nature. Insurance companies are smart because they include more exceptions than inclusions, Unfortunate. So there are some articles on the internet. You can find them. Does COVID protect me, or is it an exception to payments? And there's some really good articles that I've read, and they are testing them now. It'll be interesting. The courts will test these as they come out over the next year, because most of the courts have been backlogged. For example, the cases, because I handle cases in court. Usually I go to trial at least once a year, an actual trial, but I have right now pending probably 10 or 15 cases for my clients in court or more. And all of those have been kicked out because the criminal cases are paramount. Those get first priority. So all the civil cases that were on calendar have all been pushed back 9 months. So everything that I have, all hearings, most of those we have telephonic hearings like this. We might do a Zoom call or a telephonic. Otherwise, to try to go in and enforce something in court, unless you can prove it's an emergency, they're not even going to hear your case. So it'll be interesting what happens on those, Amy or Joe, if it's a defense to how the courts handle this pandemic, because it's a problem. All right, let me go on. Bankruptcy, okay. Bankruptcy may not protect you in many scenarios. Is it a final alternative? Do I have other options? So I am not a bankruptcy attorney. I did include some, the 3 different types of bankruptcy, and I'll kind of go over what those are, but you're always best to contact a bankruptcy attorney. I'm not sure if we have any bankruptcy attorneys in the Poway Chamber. We probably do. I don't know of them that well. Amy, who do we have? I don't know if Amy can come on. Who is a good?
I believe John Musgrove does bankruptcy.
Great. So the 3 types you have, Chapter 7, 11, 13. And this past year, they've created a carve out, a new subchapter 5 under Chapter 11 for small business reorg. So now that's sort of an offshoot of Chapter 11. So Chapter 7, you hear about, I'm going to file bankruptcy. So in some circumstances, 7 is a liquidation. So you're actually just liquidating everything, closing it all down. And when you file for a bankruptcy, one of the issues for owners is that it's assigned to a trustee, a bankruptcy trustee, and you have to report everything. And when you file your bankruptcy, and you have to sign documents under penalty of perjury, that can be very dangerous for many companies and owners because they're putting everything there under a microscope. So before, I've just seen in my experience, not my personal experience, but what I've seen is when people file bankruptcy, they don't realize that someone's going to be looking through everything in their business with a fine-tooth comb. So you better be sure that you're ready for that, okay? And so for liquidation, it could be for business, individuals, and sole proprietorships when there's no substantial assets to pay debts, okay, to creditors. And I've seen where some Chapter 7s come out of Chapter 7 and they may go into and try to file a 13, or a 13 and they come out of 13 and file a 7. So when you're in the middle of one of these bankruptcy filings, which are made in the federal court, by the way, not state court, you can sometimes change them. Chapter 11, reorganization, that's for larger scale business reorgs. And I'm not sure if I put the limit, but typically you're talking over $500,000 in assets, revenues, where you have, where you want to continue to operate, but you're reorganizing. This is for large public companies typically. You hear about them where they've had, where they're filing for bankruptcy. You hear on the news about the big companies filing bankruptcy. It's typically 11, some circumstances 7 if they're just going to close down completely. But if they want to continue operating, 11. 13's for the smaller businesses, individuals with sole props. Instead of liquidating, they try to work out a plan, and they have to pay on that plan monthly. They have to continue to pay. They can't just all of a sudden file and then stop paying. So before filing bankruptcy, and when clients come to me, they say, well, what do? I say, well, you should talk to a bankruptcy attorney first. And then if the bankruptcy attorney doesn't believe that you're a candidate for that, you might also consider obviously dissolving the company or selling the company, or bringing in an investor, bring in an equity, through equity financing, through selling shares, bring in somebody else to help you keep the business afloat. So that means, obviously getting rid of some of your side of your business, but at least stopping the full scale shutdown. You can also look into bank financing, probably very difficult to get financing at a point if you're contemplating bankruptcy. And if you do file bankruptcy, then you'll have to talk to your lender. Good luck getting a bank loan for some period of time. Again, if you do consider selling or bringing in a business investor, you want to do it, you want to seek legal advice for that. And I have actually assisted a lot of businesses, and I'll talk about this in the next section of sharing that risk, bringing people in and trading out shareholders if they can't afford to continue to keep the business afloat. You might consider selling them off and bringing somebody else in. Okay, so before we go on to the next section on your business partner wants out, how do I avoid legal pitfalls? Does anyone have any questions on the line here? Okay, and if you can use the raise hand function if you do. So this next section is very similar. It kind of has some crossover to the bankruptcy section, and we can talk about this. Okay, this is the type of situation where you're in a business. Let's say you and your best buddy decided to go into business. You operated for a couple of years, or it could be with a family member. And guess what? It's not working out. There's personality problems. There's finance problems. The revenues aren't coming in. We can't continue to keep the business afloat. And the typical scenarios, this is the situation where it's like a business divorce, where people aren't seeing eye to eye. There's one partner's putting more money than the other. One partner's spending 80% more time or in the business where the other's spending 20% of their time. One of the partners decides to start a side business. They're diverting business away from the company. All these things that I've seen as a business attorney and a litigator. I've had situations where the partner shows up, I say partner, but a shareholder shows up to the business, they open up their computer and everything has been cleaned out. All of their inventory, for example, this was a party rental business, and the other partner decided to take down all of the photographs, all of their ads from the website, and they actually just moved it over. They shut it down and they moved it over to a new company that this partner had set up. So you can see that's very disruptive to a business when you show up and that happens. I've seen shutouts where they've locked the business, where they've locked the shareholder out of the bank accounts. They've locked the shareholders out of the business, even the actual, their computers. They've locked them out of the actual physical location. You can see everything. So in that kind of situation, when they come to me, I could file an action in court for a temporary restraining order and a lawsuit for breach of contract and breach of the bylaws, and try to get immediate relief from the court that other shareholder or partner puts everything back and maintains the status quo until we've reached an informal agreement, like a settlement agreement or a buy-sell, or the court makes their own order if the parties cannot come to an agreement themselves. So like right now, I'm working with some clients that they're doing great, all right? But what they're doing is they're planning ahead. We're working on a buy-sell cross-purchase agreement so that if either one of them, because they're 50-50 owners, decide to sell, or if there's an event such as death or disability or bankruptcy, we with a valuation of the business, and we come up with a payout, how they're going to pay on that buy-sell in the future. And we also have obtained insurance, okay, life insurance and disability insurance to pay off the other partner, okay? So they're planning ahead like a life insurance event for an event that may occur in the future to buy out the other partner. Now, it may not have to be death, because in the circumstance of one party wanting to retire, then they could use that cross purchase. So they come up with a value now, and there's a provision in the agreement that every year the CPA has to go and evaluate the business for how much the buyout will be. And you could have that with a family member, because what happens if someone, let's say someone unfortunately dies of COVID, your partner dies of COVID the next day, well, guess who's going to be your partner? Probably the heir, right? The husband or wife of the deceased partner, a child, they are going to be your partner. So you want to have a situation where you know exactly, okay, this is the buyout. This is what's going to be paid. Otherwise, you have litigation over the value. They want $10 million for that 50-50 share when it's only worth $2 million, or it's only worth $500,000. You want to avoid the legal cost and the headache. So why not prepare and get that agreement in place ahead of time? And if you can get insurance in place to pay for that, great. You talk to a life insurance agent, because you're not going to get life insurance for a buyout if the parties most likely are over probably 50 years old, 60 years old, unfortunately. Insurance companies don't want to take, it's going to be extremely expensive, right? All right. if you have a situation where the partner wants out, you want to obtain, if you can, an informal agreement on how you're going to operate in the future. Get that in writing. You can have a lawyer draw it up. You could draw it up between yourselves, like a letter of intent, a non-binding letter of intent, or a memorandum of understanding. And you could give it to an attorney to put a little bit of their own little legalese in that agreement to make it binding. And then I can turn it into a contract, or your corporate attorney can review that and we can put it in the minutes that that was the agreement of the parties moving forward until we find out what is our next step, which could be a buyout of their interest, bringing in another shareholder, or if the company's having major problems, the dissolution of the entire company. Bankruptcy, that might be an option for the company, a Chapter 7 or say 11 or a 13. But you want to have something in place in the meantime, because what happens many times is once you start having these problems, I've seen where the partners go in and start withdrawing funds out of the corporate account. Okay, they feel that they're entitled to a little distribution, right, or a dividend without the consent of the other party, or they feel that if they don't take the money out of the corporate account, then the other partner is going to take the money. So it's like a rush to the bank to grab all the money, and then there's no money to pay rent, there's no money to pay payroll, and there's problems with the IRS, problems with the landlord, and it's just a cascading snowball effect. So hopefully you're dealing with people that are reasonable and rational, and that they'll enter into an agreement to how you're going to operate, how you're going to deal with the banking, the payment of the payroll, and the handling of the lease during a problem, during a dispute. Again, you could look into financing, you can look into bringing in equity partners to try to keep the business afloat. Anything you do, get it in writing. Oral agreements in many circumstances are going to be unenforceable because not the bylaws many times have language that states that changes to the agreement have to be in writing. So if the parties talk about it on the phone or in a meeting and it's not documented in writing, that's a problem. It's not enforceable. The other thing that I've seen is people have a long chain of emails. Many times I've been able to create a contract through the emails. That can form a contract. If someone says, I will do this, and they put in the agreement, agreed, that can form the basis of a contract. But you're always best having the agreement in writing, signed, dated, so we know exactly that it's a binding contract. If you do have legal counsel, corporate counsel, what I've found many times is you want to avoid conflicts of interest. So for example, you have one corporate counsel, and that corporate counsel is friends, golf buddies with the president, and you happen to be the vice president. Well, guess what? That corporate counsel has a conflict of interest because does that counsel have your best interest at heart? Probably not. So it's always best that each shareholder have their own counsel look at these agreements and give advice to each separate shareholder. I've seen circumstances where the corporation has its own attorney, and each shareholder has their own independent attorney. That's the best way to go. And I'm not doing that to try to get business. I'm doing that to try to protect the interests of each individual shareholder and the interest of the corporation. So you have to consider, does this attorney have my best interests? And I've stepped into cases where I told that lawyer, I said, you are conflicted out for everything now. I said, this is no good. And I believe it's an ethical violation of what they have done in the past. And I advise them to get new counsel. Okay, so I have, if you have any questions, I'll open it up to any Q&A. But if you have any questions, feel free to call my office. I put the number down at 858-707-7772. I'm located here in Carmel Mountain Ranch, and I've been at this office location since 2012. But I've been in the area for, like I said, close to 20 years. So any other questions of people here now?
Chris, I think most of the questions are going to be a direct contact. I went back and I checked to make sure that we do have the previous seminar, webinar on our homepage. We do. Once we have this link, I'll get an email on the link. I'll send it to Amy and we'll get it posted for our membership out there. As I said, last time it doubled the amount of folks that we had in the actual live webinar, but it does have your contact information that you left on here. So people will be able to look at there, but we'll also include it in our message out to our membership as well.
Well, that's greatly appreciated. Yes, I have my contact up there, and many times it's just a matter of contacting their own business attorney or corporate counsel to make sure that everything is compliant. There's so many different types of lawyers out there, corporate lawyers, real estate, business, you name it. But the best thing is to make sure, even if you spend a half hour on an issue, to make sure everything's done properly. It's just not worth cutting corners right now. It's too risky. But so if anyone has any questions, otherwise, I really appreciate being able to present.
I have a question, Chris. So liability for COVID-19. You know, a lot of people, I think, feel that this virus is still not real. You know, and having people come into your office or you going out to clients' locations and them refusing to take precautions, I'll just leave it as that. You know, if someone comes down with COVID-19 from that situation, whether they were given it or you gave it to them, what kind of liability are we looking at? Or how can we prevent that liability?
Yeah, that's a good question. And I have not dealt with any COVID-19 because I do personal injury. I have not dealt with having to prosecute that type of case. But I do know that there are, you know, we have posted on the door of our office the recommended postings that are out there from the county, I believe. And I'm not sure if there's any from the city. And it states, like, when you walk into my office, there's a sign that says, please wear a mask, right? And that there's COVID-19 protocol in place, that, and there's an outline of things in there that we're doing to try to protect them. In my business, I've advised that we do not have person-to-person meetings, that we can do this over the telephone or a Zoom call. I'm on Zoom calls daily. And if they need to drop off information, which I had a client drop off some plans yesterday, some big, huge blueprints that you can't send via email, that's fine. They dropped them off at the front and they left. So what I'm trying to tell people is, let's not have contact right now. And if you choose to do so, that's fine, it's at your own risk. But I choose not to meet with them personally. And so the circumstances of, if they're going to try to hold your business liable for that, the problem with that is going to be, how are you ever going to prove causation? Because in a personal injury case that we deal with, you have to prove liability, that the person's liable for the act. Number two, causation, that they caused the person to be injured or contact COVID. And three, what are the damages? Okay, so how are they going to prove that they actually contacted COVID, the virus, through you, through your contact, and not through some contact that they had at the drive-in a fast food that they just went to, or the bank that they were at a couple days before. I think it's going to be extremely difficult to prove injury through COVID-19.
Well, that brings up the case where they're now doing the tracking now, and California is now doing tracking through smartphones. So they can have a cause and effect going forward. You know, just because you were in a location and person had COVID and you were exposed to it, that's where I'm kind of like going, okay, how do we protect ourselves from any of this? And I guess the answer is you don't, right?
Yeah, it's going to be very tough to protect yourself. So is it your concern, Joe, that you're sending people out, your staff out to a business to do work for them, and they're wearing masks, and you're concerned about your staff giving the COVID to a customer, or you go out there and your staff receives it?
Well, both. I mean, we have a policy that I send out to customers that they have to agree upon. And our policy says, you know, we will only come on site, and currently, you know, we're not doing any Soho businesses at all. It has to be a business location. But if we do go out, you know, we will require our staff to wear masks, wear gloves. We'll disinfect the area and the equipment that we are working on prior to touching it. And we require that they stay 10 feet away and that they must use a mask when greeting us. But, you know, beyond that, it still doesn't protect you. I mean, the mask only protects the from you passing it on to somebody else, because we're not wearing, you know, N95 masks. We're not wearing full masks. And, you know, that's the falsehood. Yeah, you have a mask on, but if you have it and you have it in your location, so like, you know, if you go to some office, and let's say I go to your office and you happen to have COVID and you don't know it, but you sneeze, and then I walk into that office, well, my mask and gloves aren't going to protect me. And so I could receive COVID-19, you know, and I won't know about it for 10 to 14 days, possibly.
Correct.
So, I mean, that's where so I don't know if my policy is really trying to protect us or protect the client, you know, with that. So I guess that's the whole question behind that.
Yeah, and it sounds like what you've instituted are some pretty good measures, and I think that goes a long way. The fact that you have measures in place and they're in writing and they're emailed and they're on your website and they're emailed to the clients, that you are using all COVID precautions in your business, and you show up and you actually follow through with those, that's going to help in a court of law, because that's showing you've used reasonable care in your practice to avoid injury to others. That's that negligence, because what you're going to probably see are negligence cases against businesses for failing to follow any kind of COVID protocol. It's not perfect, and your insurance company is probably not going to cover it. So if they do go after you, you're going to be, business is going to be held liable, or the individuals are going to be held liable if they're not operating through a company. So that's really important. The other thing is the business, and I haven't done a lot of research on this. I'm just thinking this right off the top of my head here. But are you on some of the businesses that the current order from the governor, stay home order, or the non-essential versus essential businesses? I think businesses really need to look at that information to see, are they legally allowed to be out doing business and making calls? Like your business is IT, you have to go on site many times. Is that legal? I don't know. Is your business an essential business? Are you allowed to go out and visit customers? Because if you're not, then the question is, what can you do? What can the customers do? Like, I know many times when I'm working with you, because Joe's my IT consultant, can I just do certain things myself and then I need permissions to get into my computer, and you do it offsite?
Well, I mean, we do 90% of our business currently, and we have been for well over a year, last couple of years, is remote work. As long as we can get access to the system remotely and be able to fix it. But, there are times when you have to physically go on site. If their internet's down, yes, you can't really do anything remotely. You have to go on site to figure out what's going on. So, I mean, there are those situations. We try to very limit that. I mean, our first response is, we could do it remotely, fine. And if you are a Soho business and we can do it remotely, we will. Otherwise, you can bring the system here, drop it off to our front door, and we'll disinfect it and work on it. But yeah.
The other thing I was thinking of is a release, a waiver and release agreement. And many of these places have those. Like if you enter, you might have to sign something. So you could, that's something you and I can talk about offline, but you could consider having the clients sign a release of liability against you and your company, your staff.
Well, that's what we do with our COVID-19 policy. We send that to them and they have to agree to that policy prior to us coming on site.
And the question is whether or not those waivers and releases are enforceable in court. In many circumstances, they're not. And even though you have a waiver and release, doesn't mean they're not going to sue you, right?
That's correct. Especially in the state of California.
Yeah, one of the most adversarial places on earth. So I think it's good to have that contract anyway, and have them sign it. Why not? So let a court tell you that it's unenforceable. To have it, have a COVID policy like you have, and have a release in there than not have one. All they can do is just set it aside.
Yeah.
They can do, right?
Okay, thank you.
Yeah, and again, a disclaimer that any of the information in this conference is for educational purposes, and to be legal advice.
That's a good way to end it right there, by letting them know specifically that. But Chris, we'll go ahead. We'll stop the recording right now. We'll get it posted for you. We'll put out your contact information in case others need to get a hold of you once they view it. And then we'll also get the information out to our membership that it's been posted already. And on behalf of Mike and Amy and everyone, the whole staff at the chamber and all our membership, we thank you for your dedication to getting this valuable information out to everyone. And we'll reach out to you in the future if we need more information as well.
Thank you very much, David. Thank you, Amy, and nice talking to you, Joe.
All right.
Appreciate
All right. Take care now.
Bye-bye.
Yeah,
Have a good day.
thank you.
Bye.
Bye.